My name is Chad Cunningham, and I'm the Loss Control Director here at Insurance Board. Now I'd like to welcome you to this time of learning with our topic EPL Risk Management 360, Smart Hiring, Compliance, and Litigation Readiness. Without further ado, I have the pleasure of introducing our speaker today, Jonathan Heller from Littler. Jonathan advises organizations in reducing legal risk through compliant employment practices, including investigations, performance management, and difficult employment decisions. He also brings litigation experience and insights from his in-house and U.S. Army JAG service to help organizations proactively minimize exposure to claims. So without further ado, we'd like to welcome Jonathan, and the stage is yours.
Thank you so much, Chad. And I would just like to thank everybody for attending today. It's an honor and a pleasure to be presenting to you. I recognize that the work you do is incredibly important, not only to the members of your parish, but to your community. And it's my hope that by way of today's presentation, I will be able to assist you in some form or fashion. As I've shared with Chad before, one of the primary focuses of my practice is to take a proactive stance on issues. And as I'm sure all of you know, when it comes to issues in the employment realm, whether it's onboarding, terminating employees, managing performance, dealing with claims, or dealing with litigation, being one step ahead of the game is imperative. To that end, what I do on a regular basis is work with my clients to try to ward off and avoid litigation. Now, that's not to say that I just tell my clients, go ahead, pay what they're asking you for. Rather, I try to take an approach where we can set the foundation for an organization that will allow for it to minimize the potential for risk. At the end of the day, my job is really to mitigate risk and to protect my clients. So for the purposes of today's presentation, as Chad shared with you, I'm not going to be using any kind of PowerPoint presentation, as I find that it's a good way to ensure that your audience falls asleep. And oftentimes when my colleagues do those types of presentations, I see them just reading from the slides. And something tells me that we probably have about 100% literacy rate in this group of esteemed folks. So I figured it would be better for me to go a bit ad hoc here and to go through some primary topics that I believe will be of importance to you and to your organization. The first topic that I would like to discuss with you is a fairly broad one, and it's the best practices when it comes to employment law. As you know, employment law is a minefield for employers. You're dealing with all manner of issues from problematic employees, underperforming employees, dealing with oftentimes a human resources department that is not fully staffed and as a result might be missing certain issues, whether it has to do with pay and remuneration or ensuring that employees are provided with all the necessary tools to do their job. I'd like to start out with the issue of the position description and job postings. Regarding the latter, job postings, depending on where your church is located, there may be a state law requirement that mandates that when you post a job online, that you include the salary range or the likely salary range. For instance, here in California, where I'm located in practice, 2 years ago, I believe it was, there was a law that went into effect that required all job postings to include the range for that job. The purpose for that was transparency. The idea being that oftentimes you'll have two different applicants who go up for a job, and one applicant might not have as much, let's say, negotiation or negotiating savvy. And as a result, they are not able to obtain the salary that one of their similarly situated peers might otherwise be able to obtain. Excuse me. In addition to ensuring that your job postings are done in a manner that is aligned with state and federal law, it's also important that you review the job posting prior to putting it anywhere online, be it LinkedIn or otherwise. And some of the questions that you should be asking yourself are, is this job description up to date? Is this position properly classified as exempt or non-exempt? Is the job posting being done publicly along the lines of what I just discussed in terms of sharing it on LinkedIn or other similar websites? And if so, does it share the relevant pay band? Now, we just addressed the latter two, my earlier comment. But in terms of the job description, when I say is it up to date, what I mean is pretty straightforward. When was the last time it was reviewed? And has the position in any way changed since the time when the job description was written? You'd be surprised how many clients I deal with who are using job descriptions that are oftentimes 10 to 15 years out of date. This can become a major issue, not necessarily right when the individual takes the position, but down the road when there are certain expectations that the organization has of that individual that were not otherwise listed in the description. Now, as I'm sure you know, most job descriptions include language along the lines of, quote, applicant and or employee will also be assigned additional duties as needed by the organization, unquote. That's a catch-all that's meant to suggest that the job description itself doesn't speak to everything that's going to be asked of that individual. Nonetheless, along with my colleagues at Littler Mendelson, I always counsel my clients to regularly update their job descriptions or to at least review them on an annual or semi-annual basis. In terms of the classification issue, that is, whether an employee is exempt or non-exempt, this is an area that admittedly tricks a lot of people. Exempt is pretty straightforward. That means that the individual is exempt from the provisions of the labor code. For instance, as a shareholder with my law firm, I am not eligible for overtime, meal breaks, rest breaks, or any of the other wage and hour matters that might otherwise come to the forefront were there to be some litigation. However, my secretary, who is a non-exempt employee, is eligible for overtime and such breaks that I laid out. As such, that means that she and I are treated differently by our organization when it comes to pay and remuneration, but also it is important that my organization tracks her hours, whereas my hours are less at issue. In fact, any time a company or organization is bringing on an employee who is otherwise deemed to be non-exempt from the labor code provisions of the state in which they work, it is of the utmost importance that you ensure that that person is given training and materials related to the labor code. What I mean by that is actually quite simple, and I realize I might be burying the lead, but a lot of organizations use a pretty straightforward employee handbook that contains the organization's policies, which are typically just derived from the labor code itself. They will list when and how an employee is to take breaks, where and how an employee is supposed to clock in and out of work, and other items associated with the employee's hourly work. The next step when it comes to employment best practices is what to do when you have hired an employee. I call this the onboarding logistics. One thing that I tend to do for my clients when they ask me for something having to do with onboarding is provide them with what I would call new employee onboarding checklists. This will involve everything from big picture information, information about the position, safety and security, where they're going to be working, the building information, reporting information related to hours, 4 hours and overtime, the logistics, the expectations of the organization, which, as I mentioned, are often memorialized in an employee handbook, the standards of professionalism and standards of conduct, what to do in cases of an emergency, how to address concerns or complaints, whether they deal with matters related to sexual harassment or workplace violence, or even just ethical issues or concerns, employee self-service to include employee assistance programs, and any next steps. For instance, many organizations will have training plans for newly hired employees to ensure that those employees are effectuating the intent of the organization and that they are succeeding in their jobs. From there, you'll probably want to also apprise your employees of performance management, the way it is done, what their expectations are related to the same, as well as any policies or training that that employee will need to take on. At the outset of onboarding, as you probably already know, one of the primary things that you will need to do is to ensure I-9 compliance. This is typically done by way of the I-9 form, which can be found on the IRS website, which you will have new hires fill out. This is to ensure that this person is legally qualified to work in the United States. And as we've seen over the last 15 months with crackdowns related to immigration, this is becoming more and more of an issue where employers are having trouble and where they are potentially facing some liability, whether it is from state or federal agencies, or even from individuals who are claiming that they were not properly vetted. You will also want to ensure that your employees or new hires are filling out all of the relevant tax forms to ensure that they are paid on a timely basis. This matters not just so that the organization can have that incredibly important information, but also so that your organization is not violating any wage or hour laws that are typically codified in your state's labor code provisions. At the time of onboarding, or perhaps shortly before that time, you will also want to conduct what is called a minimum wage analysis. The way in which that is done is understanding what the minimum wage is where the employee is conducting their work. For instance, let's assume that I am running a business here in San Jose, California, but I am hiring an employee who lives in Dayton, Ohio. It's important that I understand what the minimum wage is in the state of Ohio, as well as whether there is any local or municipal wage ordinances that apply to the area in which that employee works, and or the category in which that employee works. For instance, and I'm sure this is no shock to anyone on this call, here in California, we have probably more employment laws than any other state in the country. And as you can imagine, that keeps me very busy. What that means is that when I'm advising a client who is onboarding employees, I need to check where the employee works. Are they in California? If so, what county are they in? And let's just say that they work in Los Angeles County. Los Angeles County has a number of municipalities within it to include the city of Los Angeles, the city of West Hollywood, the city of Santa Monica, all of which have their own different wage ordinances. Those wage ordinances apply to issues related to minimum wages, as well as minimum wages for certain types of businesses. Now, given that I'm speaking to a group here that, as I understand it, you all are run houses of faith, I don't imagine that that latter issue will apply to you. That is, I don't imagine that any ordinances having to do with the type of job will apply to you. But it still remains very, very important that you look to see what the minimum wage is. A failure to pay a minimum wage can lead to a claim not just for that failure, but for the failure to have timely pay at the time of termination and during the time of employment, as well as claims related to inaccurate wage statements. Additionally, and we will discuss this issue in just a moment in far greater depth, you will want to ensure that your employee is not only properly classified as exempt or non-exempt, but if the nature of the employment is different from that of a typical W-2 employee, in other words, an independent contractor or consultant, you will want to ensure that that person is indeed properly classified. This typically requires somewhat of a legal analysis, and it is an issue that we would be glad to assist you with. It doesn't typically take that long, and once you have that analysis, you can probably use it for most other positions. Before we before we go into further depth about the issue of misclassification, as I mentioned earlier, it's very important that your organization share with any new hires, as well as existing employees, those policies that govern the terms and conditions of their employment. The reason for this is clear. If if they did not have if they did not already have notice of the rules under which they would be working, there are questions as to how they could be expected to abide by the same. Many of our clients desire what's called an employee handbook. This is typically exactly what it sounds like, and it is a compendium of rules, policies, and regulations that apply to the employee's employment with your organization. Oftentimes, we have clients who get these items through third-party vendors like ADP or other similar companies. While I can't speak ill or highly of those organizations, I would say that they are not legal institutions, they are not law firms, and so I always advise my clients that if they are looking for changes to employee handbooks, policies, or even just the review of the same, that they reach out to us so that we may try to assist them in that. Additionally, and I believe that this issue is particularly relevant as you represent churches, um, I always like to advise my clients that they should consider having their employees sign an arbitration agreement. An arbitration agreement is exactly what it sounds like, and it is pretty straightforward. It is an agreement between the employer and the employee. Therein, the employee is waiving their right to bring claims against the employer in a court of competent jurisdiction, and instead is submitting to having those claims heard, should they be heard, should that individual bring claims, before an individual single arbitrator who is authorized to make a final and full decision. Arbitration is private. The results of the same are not posted, unlike any type of litigation in a court of competent jurisdiction, as those courts make their records open to the public. The reason that this is helpful for many organizations of faith is fairly clear cut. For instance, 2 years ago, I was working with a church out here in the state of California. At the time, there was a claim of harassment that was raised by a younger female employee against one of the pastors of the church who was in charge of youth services. We conducted an investigation and we learned that this youth pastor had indeed made some very inappropriate comments and had made the young individual feel uncomfortable at various turns. While it did not rise to the level of sexual harassment, and while we were able to resolve the claims, one thing that I noted for that client was what I just shared with you, the benefit of having an arbitration agreement. The reason I say that is I recognize that many of your churches are probably in smaller communities with tightly knit communities. And the last thing we would want for you or for your organization is for your reputation to be sullied by the accusations of one or multiple individuals, whether those accusations are true or not. Were you to have an arbitration agreement, that would help to ensure privacy of the matter, which admittedly, and I say this a lot, is worth its weight in gold. Now, admittedly, the relevant requirements do vary state to state, but for the most part, we are able to draft arbitration agreements for you that are straightforward and that should effectuate the intent of keeping things private and protecting your company, or excuse me, your organization's interests to the fullest extent possible. Now, as I transition into this next topic, I want to warn you, it is somewhat of a minefield for legal claims. The topic is misclassification. That is, are you paying your employees on a W-2 or a 1099? If it's the former, they are an employee and they are eligible for benefits. If it's the latter, they are an independent contractor or a consultant. Independent contractors and consultants are not eligible for benefits. Ergo, it's imperative that you do not cross the proverbial streams and provide benefits to those who are not indeed employees. Unfortunately, because we are a federation of 50 states, there are many tests to determine who is and is not an independent contractor. For instance, there is what's called the common law control test. This test focuses on whether the organization has the right to control not only the result of the work, but also the means and the methods by which the work is performed. The IRS uses this test, and they're informed by a rather lengthy 20-factor analysis to determine whether a worker is an employee under federal tax law. The more control that your organization exercises over how the work is done, the more likely that worker is to be deemed an employee. For instance, let's assume that your organization hires an individual to perform services on a part-time basis as a pastor. Now, if your organization asks that the newly hired pastor vet his or her homilies or any information that they are going to put out during Sunday services, that is likely to suggest that they're an employee because they're under your control. However, if the opposite exists, then that is more likely to suggest that they are an independent contractor. As I mentioned, there are a number of other tests. One of these other tests is called the economic realities test, which examines whether the worker is economically dependent on the organization or whether that individual worker is truly in business for themselves. This test looks at, you guessed it, the economic realities of the relationship. For example, whether the worker provides services to multiple clients, invests in their own tools and equipment, and bears the risk of profit or loss. If you have an employee, if you bring somebody on and you want them, let's say, to do repair work on the various pews in your church, but you have a very set plan. Let's just say we need repair of 6 pews. We're not going to tell you how to do your work. We're not going to tell you when to do your work. We expect you will do it in a professional manner. That is likely to suggest that you have hired an independent contractor. It would be even more likely that that person is an independent contractor if they are doing work for multiple entities, and those entities need not just be churches. For instance, that carpenter could be doing work, let's say, at a local school or some other organization. And as to the tools and equipment, if they are bringing in their own tools and equipment as opposed to having you supply them, that further weighs in favor of them being an independent contractor. The same is true for bearing the risk of profit or loss. That is, they are responsible for their own economic affairs. Here in California, and this test has been adopted elsewhere, we have been working under a rubric called the ABC test. Under this test, a worker is considered to be an independent contractor only if all of the 3 conditions I'm about to lay out are met. 1, the worker is free from the control and direction, both under the contract and in fact. 2, the work is performed outside the usual course of the hiring entity's business or outside its places of business. And 3, the worker is customarily engaged in an independent established trade, occupation, or business. Now, this test is generally viewed as more restrictive, making it harder to classify a worker as an independent contractor, but admittedly, it is not used as broadly as some of these other tests. Now, using the example that I shared before about a carpenter, and as you can imagine, I shared that for good reason, not just to joke around, but given what I think we know about Jesus's day job. If the individual is a carpenter, I think that each one of your organizations can likely say, well, hey, this person would be an independent contractor because the work he's performing or she's performing is outside the usual course of our business. Our business is essentially sharing the gospel with our parish. Moreover, and presumably, this individual is going to be free from the control and direction of your organization, other than to say, we need you to build some pews. You figure out the details. So that is a way for an organization to ensure that proper classification is being met. Now, there are indeed statutory classifications for the purposes of federal tax law. For instance, the Internal Revenue Code also defines certain statutory employees and statutory independent contractors. For example, and again, this doesn't apply to your organization most likely, but a real estate agent is a statutory independent contractor if that individual is a licensed real estate agent working as a salesperson, receiving substantially all remuneration based on sales or output rather than hours worked, and the services are being performed under a written contract stating that the individual will not be treated as an employee for federal tax purposes. Now, the indicators of an independent contractor relationship um, can be many, but an independent contractor typically has autonomy to organize and carry out work according to their own methods, set their own schedules, use their own tools and resources, manage their own expenses and taxes, and may work for multiple clients, as I mentioned, at the same time. This lack of subordination between the independent contractor beneath your organization means that the worker is not under the control or direction of your organization. And that is a fundamental characteristic of an independent contractor relationship. In practice, proper classification requires evaluating all relevant facts under the applicable test. Thankfully, I work with many colleagues far smarter than I who can assist if you find yourself in a situation where you need assistance with classification. Some red flags that I would like for you to be aware of today are where the independent contractor is a former employee, the independent contractor performs the same work as employees of your organization, the independent contractor agreement includes a non-compete provision, or the independent contractor is paid by the hour and not by the project. All four of those situations would weigh in favor of a judge or arbitrator making a finding that the individual was an employee. The reason that is so important is because then you would not only owe back taxes to the IRS, but you would owe benefits and various other forms of remuneration to that independent contractor who had been mischaracterized as such. Additionally, there are red flags where an organization provides training, controls those hours worked, provides the tools or equipment, or reimburses the independent contractor for business expenses. As to that last point, business expenses are not to be reimbursed for an independent contractor. In fact, the independent contractor should build that into their budget. In other words, if, using our earlier example, you hire an independent contractor to repair or replace some pews in your church, you will want to ensure that their proposal includes all costs and expenses that they believe they will incur. Now, why does this matter? I sort of hit on this a little bit earlier, but misclassification can lead to significant tax, wage, and benefit liabilities. So it's important to document the relationship carefully and ensure that the facts align with the claimed classification by your organization. Critical benefits and protections depend on employment status. For instance, workers' compensation, unemployment insurance, and the unemployment insurance benefits that might flow from that, wage and hour concerns under state labor codes and the FLSA. This includes meal and rest breaks, reimbursement for business expenses, as well as overtime and minimum wage considerations. Other important benefits and protections that depend on employment status include taxes, claims before the Equal Employment Opportunity Commission, and benefits. For instance, healthcare under the Affordable Care Act, 401k plans, stock plans, pension plans, or other such plans that might be afforded to employees. Those should never be afforded to independent contractors, as blurring that line could lead to a finding that the individual is indeed an employee and not an independent contractor. Now, in practice, I want to share a little bit more because we've kind of been going over these are the rules, these are the theories. And while I enjoyed my time in law school, what I found lacking is while you can learn a lot from legal theory, it's not going to teach you how to do your job. Rather, most of how we learn how to do our job is doing our job. So I want to evaluate independent contractor status. Let's assume over here on this side, we have an independent contractor, and over here we have an employee. The independent contractor is an individual who controls when, where, and how the work is performed, and controls the sequence and hours of work. On the other hand, the employee is working under a different rubric. There, the organization prohibits that individual from working for competitors or otherwise makes it impracticable to work elsewhere. Similarly, when we look at the issue of duration, with an independent contractor, the contract is for the duration of a project or for less than a year. The independent contractor has time to work for other firms, organizations, searches, whomever they want to work for. Similarly, the employee, their relationship with the employer is continuous. It is indefinite or it is full-time. The company thus may impose certain restrictions for leaving. When we look at the issue of investment, with the independent contractor, we have an individual who is making a significant investment in facilities, equipment, or helpers, typically in the form of their own employees. Whereas for an employee, the company or organization is providing that individual with tools, equipment, and other business expenses required for the work. For instance, something tells me that your organization provides to your employees various items that they need to do their work, whether it is a computer and access to the internet, or perhaps it is some items associated with the services that take place in your various churches. As we further evaluate whether the status of an individual as either an independent contractor or an employee, it's also important to look at their skills, the opportunity for profit or loss, and integration. As for skills, with an independent contractor, the work is typically being performed by a highly skilled individual or professional. With an employee, the work performed can be unskilled, routine, or repetitive. Think like data entry. When it comes to the issue of profit and loss, on the one hand, we have an independent contractor. Their decisions, for instance, to rent space, to hire employees, to advertise, can affect their profit or loss beyond the current project that they are undertaking on behalf of your organization. On the opposite side, the employee, the individual can only increase profit by working more hours, and they can't incur a loss because you can't charge your employees, you can only pay them. Lastly, with the issue of integration, the work performed by an independent contractor is not related to the company's main line of business and not performed by company employees. I was getting at that issue earlier, but using the example of most of your organizations, the chances are that the ministers, priests, or other faith leaders who work for your organization are employees. Because typically, for a house of faith, that is the focus of that organization. However, using the carpenter example I used before, typically a house of faith is not in the business of building pews or other things. So an independent contractor situation with a carpenter would make a lot of sense. However, when we look at an employee, the employee's work for the organization is essential to the organization's business and is performed by the organization's employees. Now, we've just spent a decent amount of time going over the differences between independent contractors and employees. And I can assure you, there is so much more for us to explore in this space. That being said, I don't want to put you to sleep any earlier than you need to get to bed today. And so if you have further questions related to misclassification claims, what is required by you in terms of hiring or onboarding or ensuring that the individual whom you are bringing on is indeed properly classified, do not hesitate to reach out to me, and either I or one of my many wonderful colleagues will be glad to assist you. In fact, we have plenty of resources that we can push your way to share with you to help you ensure that you are doing everything in a legally tenable way. Now, there are there are three additional topics that are fairly broad that I would like to go over before we turn this over for some Q&A. The first is handling a lawsuit from cradle to the grave, specific to organizations that carry an employment practices liability insurance policy. Oftentimes, a company or organization will receive what's called a demand letter or a claims letter. Typically, this is coming from a former employee who is seeking to grieve their claims or complaints with the organization. Upon receipt of such a demand, I recommend that you do two things. One, reach out to your EPL carrier, and two, reach out to your attorney. The third thing you should do is connect the two of them. The reason for that is that timely submission of claims to your EPL carrier is imperative because it allows your carrier to make an informed opinion as to coverage, that is, whether the claims alleged by the, in this case, former employee, are indeed covered by your by your policy. The second reason that's incredibly important is before you start engaging with counsel, whether you have an attorney or do not, you will need to work with your insurer to determine whether you may proceed with that firm. For instance, my law firm is on many panels with many insurers, which means that we've already been pre-approved by those panels to assist the insured companies or organizations that work with that insurance company. That's not the case for all firms. And any money that you spend on your attorney, you will want to get as much of it reimbursed to you from your insurance carrier. However, if you don't inform your insurer, there is a chance that you might not get that information. And by information, I meant reimbursement. After reaching out and connecting your attorney and your EPL carrier, you will want to either conduct an internal or have an attorney conduct an external investigation into the issues put forth by way of the claim or demand. That can be something as simple as having someone like myself meet with the relevant fact witnesses at your organization, typically over Zoom, wherein I would ask them questions related to the demand and the claims at issue. And those interviews would be privileged, subject to the attorney-client privilege and attorney work product. And as such, they wouldn't be turned over to anyone. One of the reasons why I, along with my colleagues, recommend early investigations is that, as you probably know, bad facts do not have a tendency to get better over time. I would rather always know everything up front, the good, the bad, and the ugly. Along with my colleagues, we would work to allow for that investigation to be privileged and to ensure that we can get all information relevant to the claims. When you receive a claim, it might come at the same time or shortly before a lawsuit is filed associated with the same claim. Lawsuits typically have a 30-day response period for the organization that has been sued. What that means is you only have 30 days in which to file either an answer to the complaint or some other form of responsive pleading laying out the organization's defenses or arguments as to why the lawsuit has no merit. 30 days seems like a lot of time, but I can assure you it goes by very quickly. And as somebody who prefers to take that proactive stance and to get the work done today rather than the night before it's due, we appreciate that heads up and the time to do it. In conjunction with your external counsel, as well as your insurance representative, you will want to develop the best course of action for dealing with the lawsuit. Sometimes that is early resolution, often effectuated by way of mediation or one-on-one negotiations between the attorneys for the respective parties. Oftentimes, it is a determination that the claims have no merit and that it makes more sense to defend against them and to secure a victory, be it before an arbitrator, a judge, or even by way of a pretrial dispositive motion. Admittedly, those situations must be individualized based on the circumstances and the personnel involved. Perhaps one of the most expensive and time-consuming portions of any litigation is what's called discovery. Discovery is kind of exactly what it sounds like, in that it is the opportunity for both parties to discover more about what documents, facts, or information the other side has. While I take a stance of turning over only what is legally required, that in and of itself oftentimes can amount to thousands upon thousands of pages of documents. And oftentimes, where we have significant communications that are contained in email or text message form, that requires a very long and arduous process of reviewing, date stamping, and producing those documents. In addition to written discovery, in any litigation or arbitration, you can expect that there will be depositions taken for relevant witnesses. The relevant witnesses are typically those who are closest to the complaining individual, that is the plaintiff, and who might have had oversight or day-to-day interactions with him or her. In litigation, as I mentioned, parties often seek to have the suit dismissed prior to trial by way of a dispositive motion. The standard for doing so is quite high, as courts in general tend to prefer to have a litigant have his or her day in court. That being said, one of the other ways to dispose of a matter prior to trial is to seek a negotiated settlement and resolution of claims. There are primarily two ways in which that can be effectuated. The first is to go before a private mediator. Typically, a mediation is a half or full day event where the parties for both sides appear with their attorneys, typically over Zoom, and each party individually meets with the mediator, then goes to a breakout room. And when meeting with the mediator, they lay out their case and defenses and why in this case, any resolution should be minimal based on the, let's say, specious nature of the claims alleged. Now, I had alluded to this earlier, but there are two main forums for claims: litigation and arbitration. Litigation is exactly what you think of when you see any legal procedural on television. It is offering the individual their day in court. Now, court is open, it is public, and as I mentioned, that means that anything filed there that is not subject to a protective order is, by virtue of public policy, available to everyone. This became quite a big issue, and certainly a hot topic, roughly 9 years ago at the height of the Me Too movement. As you may recall, and is certainly the case now as we deal with the daily fallout from the Epstein files, anytime something is in a court of competent jurisdiction, it can get out. That is why I advise my clients to consider having their employees sign an arbitration agreement like those that I laid out at the beginning of this presentation. Doing so allows for peace of mind in knowing that the matters at issue will not be subject to public scrutiny. However, while there are benefits for arbitration, like those I laid out, one of the downsides is the cost. For a litigant to have their day in court is free. The courts are provided to us by the state and the federal government. Arbitration is expensive because you're appearing before a neutral arbiter who is likely a retired attorney or judge and charges by the hour or perhaps the day. However, I will say that the costs of such typically outweigh the benefits of going before a court. Additionally, a well-tailored and properly drafted arbitration agreement can be used as both a carrot and a stick when considering early settlement discussions. For instance, I recently received a claim on behalf of one of my clients, wherein the individual employee who had been terminated for poor performance was alleging that her termination was due to age and sex discrimination. while I don't believe her claims, I treat them very seriously because they are obviously utmost importance to my client. However, my client had this individual sign an arbitration agreement at the outset of their employment. So I can use that as a stick when dealing with opposing counsel. And what I mean by that is I can say to opposing counsel, hey, buddy, look, if your client is hell-bent on bringing her claims, remember, we've got an arbitration agreement here. So she can't just go to court and file a lawsuit. And if she does, I will file a motion to compel arbitration on my client's behalf, and I will seek sanctions based on your failure to abide by the terms of the party's agreement contained in that arbitration provision. I can also use it as a carrot, and that carrot looks something similar to what I just described as the stick, but I can essentially tell them, we have an arbitration provision here. However, if your client is amenable, we will waive the need for any arbitration while the parties informally seek to resolve this matter. I'm not going to give them the option to just waive arbitration altogether, but at least give them time during which time, hopefully, both parties can come to some kind of negotiated settlement. Now, the final topic, makes sense if you're thinking about this sequentially, is termination and offboarding. As a preliminary matter, I believe it is incredibly important for all organizations to have a written checklist available at the time of termination. This checklist should ensure that you are in making sure that your employee receives all of their final wages in a timely manner, which varies by state. For instance, here in California, if you terminate an employee today, you better be ready to pay them today because they are, under the labor code, required to be paid out on the date of their termination. Now, if they resign, you have 48 hours, but still, you need to ensure that you are working with your finance and human resources departments to confirm that they can carry this out in the cadence that you're seeking to do so. One other thing to consider with any kind of checklist for offboarding is what other documents do I need to provide to an employee at the time of termination? Here in California, there are a number of requirements, and of course they vary state to state. But a general rule of thumb is that you're required to provide information related to any COBRA benefits to the extent that any exist. You are required to provide the terminated employee with information about how they file for unemployment in the state in which your organization exists, as well as any information related to plans or pensions that that employee was vested in or otherwise could have been vested in. As you can imagine, one of the easiest ways, and I shouldn't say easy because it's not easy so much as it is holistic, but one of the more holistic ways in which to ensure that you cross all T's and dot all I's and to avoid litigation subsequent to the termination or resignation of an employee whom you believe might bring claims is to have a severance or release agreement presented to them. Typically, that agreement offers the employee a payment. Oftentimes, it's 2 weeks for every year that that individual was with the organization, but there is no requirement for any severance. But it will typically lay out the consideration for the employee, which can be severance benefits, an extension of COBRA benefits, maybe even outplacement services or otherwise. And in exchange, the employee is foregoing and releasing any and all claims that they had or might otherwise have had against the organization. Now, I will add a caveat there. These documents, these severance and release agreements, are very nuanced. They are full of legalese, and you have to be very careful with what you're presenting to the other side. Should you have any questions, please reach out to me directly. This is one area where I am a subject matter expert. is, despite being a fairly macabre area, it is something that I enjoy doing. And I am more than happy to assist you and your organization with that or with any of the issues that we've discussed here today. Now, I know that this was going to go until noon out here on the West Coast, and I guess that would be 3 o'clock on the East Coast. I finished a few minutes early, but Chad, as I recall, I believe we were going to allow some Q&A. So I will gladly, cede back that time and offer an extended Q&A for anybody who has questions, or if there are any issues that came about during my presentation that anybody would like for me to address.
Absolutely. Well, thank you very much, Jonathan. We appreciate you taking your time to be with us today and really sharing all this great information. We do have a couple questions we'd like to share. One
Yeah.
of them is, the question is, our organist has 4 Sundays a year off. We need to hire a substitute. This would be 3 hours practice and 3 hours of service for a total of 6. We have the organ piano on site. The music is selected by our choir director. Can this person, if they do just 1 Sunday or more, be an independent contractor?
You're going to get this is the most typical answer that any attorney will ever give you, which is it depends. Based on the circumstances that were laid out in the question that Chad shared, I would say that there is a better than 50% chance that you would be able to bring that individual on as an independent contractor. The reason being is that it would likely be for a short duration, in this case, perhaps a couple of Sundays, and it would not be for an extended period of time. In addition, the tools in this case, I would argue, are not the organ or any instruments, but are the person's fingers, right? Them playing the organ itself. So to answer that question directly, if I had to go with my gut without knowing more and without having further detail shared with me, I would say that you could probably bring that person on as an independent contractor. And admittedly, one thing that I didn't address is that when you bring someone on as an independent contractor, it is incredibly important that you have a written agreement with that individual that lays out the term, scope, duration, you know, everything that you want in there. We have templates that we typically can draft in accordance with your needs. So if that is something that you would need, do not hesitate to reach out.
Excellent. Thank you.
Of course.
Next question. So this church has a bookkeeper that they pay as a contractor.
Okay.
So it's a contracting bookkeeper. This bookkeeper has other clients. It does all the work on their own schedule. We have contracted with this person for multiple years. They sometimes charges us for specific expenses. Do we need to change his classification?
I don't believe you need to change his classification, but and if the person who raised that issue can share with Chad whether there exists a written agreement, that would be helpful to know. But what I would say is you will want to adjust that agreement to ensure that the costs associated with any expenses are borne by that independent contractor. Now, naturally, that's going to kick up probably the pay per project that you send to this individual, but you will want to ensure that you have a written agreement and, excuse me, that agreement speaks to the terms and conditions.
Excellent. All right, 2 more.
Of course.
And I think we got the time. So question here is, could you talk about background and or credit checks at timing and hiring process? So, the timing of having those done within the hiring process.
Yeah. So background and credit checks are typically done after the offer of employment has been extended, but before the person's first date. In other words, what I typically advise my clients to do is as follows. You found the right person, you've interviewed them, he or she does a great job, you think they're going to be a great fit. Go ahead, March 19th, offer them the offer of employment, the letter, which if you don't already have a letter template that we can certainly assist with that. Um, the letter should always say that this offer of employment is subject to passage of a background check, background and or credit check. Um, Now, that's important because we don't want to get into a situation where we are being where there are allegations of breach of contract. So I would say once the person clears the background check, then you can say, congratulations, you've cleared the background check. We're so pleased to be onboarding you. And the reason that's important is as follows. I have I have a client who purchased another entity, and when bringing those individuals on their books, they did background checks on everybody. Now, what they learned when doing background checks is that one of the individuals was a registered sex offender. And my client's organization regularly has children in the workplace because they have like a child care facility. The reason that's important is pretty obvious. Nobody wants to have a registered sex offender near a child. So, after doing a background check, they terminated his employment. That is different because he was already an employee, but at the same time, it highlights the need for background checks and why they are so important.
Excellent. So here's one that I think we hear quite a bit in your line of work.
Yeah.
So how would you respond if there was a substitute organist who is on disability, asked to be paid in cash under the table so as not to impact their eligibility for governmental assistance?
Mhm. Be very careful because by way of your actions, if you are paying somebody under the table and that information is later learned, the IRS learns of it, you might owe back taxes, you might owe penalties, and it is just one of those situations you want to avoid. Um, in addition to that, the individual whom you are paying under the table, so to speak, they may very well, the relationship may sour. And if the relationship sours and they bring that up, if they later say, like, before a court or an arbitrator, I had been paid under the table and we had a deal, yada, 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 um, your organization can look very, very bad. So I would recommend that you not do that in any situation.
Okay, excellent. Last question I have in our Q&A here. Um, so this organization has an employee who actually happens to be an organist. That's the key today. Something's going on with our organist and our
Yeah.
pianists in our churches, but we all love them. Um, who has who also pays rent to the church for space to give piano lessons. So she is basically an independent contractor. Any red flags?
Can you repeat the part about the space? So she's an independent contractor, she's the organist, and did you say that she rents the space or
So she's an employee,
employee? Okay.
basically an employee who also pays rent for space.
I guess I would need to know a bit
That'd be a
more.
lease, yeah.
I'm sorry.
Wouldn't that be a leasee and a leaser agreement more
It,
than
it, yeah, that would be. And
employment?
admittedly, I would be careful about that because, and it's funny because admittedly, whatever you throw at me in terms of a factual scenario, I've probably seen it by now. I have a case that's not that dissimilar, although it involves a home as opposed to, rental space. You have to be very careful when you sort of cross the individual's employment or work as an independent contractor with your organization with a separate type of agreement, like a lease, you're you're blurring the lines as to the nature of the parties' relationship, to say nothing of what we've discussed in terms of classification issues. So I'd be very, very careful with that. Um, with that question and with the previous one, there are tax implications. If they're leasing space or something like that, that might be information that the organization needs to report to the IRS. So I would always reach out to an attorney just to get 10, 15 minutes of advice on that. It's probably going to be well worth it given what the potential for penalties, costs, and fees could be down the line.
Excellent. Thank you for that. We just got one more that just jumped in under the gun. And so this group has a moderator who has been a longtime member, new moderator, so a new officer involved, and wanted to know, should they do a background checks on officers? They automatically do them on employees and volunteers, but if this one, as an officer, hasn't had one, should they have background checks completed on officers?
So it depends. Sorry, legal answer. It depends based on the type. If the officer is being provided with any kind of pay, benefits, or remuneration, that's the first inquiry. If they're not, then you probably don't need to do a background check. That being said, I am in favor of background checks simply because we want to know who's coming into, in this case, our house of worship. And I don't think I'm burying a lead here, but given some of the stories that have surrounded houses of faith over the past 20 years, it really is important that the individuals who are doing work for your organization or who represent your organization in any outward facing way are of the highest character. In this situation, without knowing more, it's difficult to provide advice on that, but I would probably weigh in favor of doing the background check.
Excellent. And if I can even add to that, Jonathan, and correct me if I'm wrong, not only that, it just kind of supports how the church is operating as a whole, to where no matter what comes in, we are responsible for, people who come in here for their safety and security, and background checks is just one concept we do on everybody to make sure everybody's safe and in line. Excellent.
Absolutely.
Okay, thank you. All right,
Were there any other questions from the group or anything else that anybody had, any concerns about?
Oh, we got through all the questions, Jonathan. I don't see anything
Easy.
else here. Yeah, this is a good group. All right, everyone. Well, thank you for everyone attending. We'll kind of end it here. If you have more questions, when we send out the emails within a week, the recording will be available. We'll send you documentation on how you can sign up for the EPL through Littler as participants within the program. You have opportunity to sign up and ask questions or get some of the great resources that they have. Even be able to maybe talk to Jonathan here or there as you go through it. But all you need to do is have your policy number, but we'll provide information on how you can do that and get signed up there. Also, just to while I have everybody here, we do have another presentation coming up in our webinar series in May 12th of 2026 on cybersecurity awareness. So we'll be talking about phishing and not with a pole and worms. So don't worry about that part. But we'll talk about some phishing and some social engineering and really talk about that. And we'll be joined by the group from the Cybersecurity and Infrastructure Agency. So that'll be out on our website in the next couple of days. You can go out and sign up for that. So again, Jonathan, we thank you very much, and Littler, for the great cooperation and partnership that we have. And you did a great job today. And we hope you have a great evening.
Thank you very much, and I appreciate the opportunity. And Chad, please feel free to pass along my contact information to all of your insured. I appreciate all the work that your insured do, and it was really wonderful to meet with you and all your insured today.
Great. Thank you. And everyone, have a great evening. Take care. Bye-bye.